Hello everybody, I am Taniya Pandey and I welcome you to this week's episode of Courts This Week on LiveLaw. In today's video, we'll be covering the important legal updates that happened in the second week of January. As usual, we'll begin the episode with judgments from the Supreme Court and then move on to other courts in the country. The Supreme Court has pulled up real estate giant Supertech for failure to reimburse home buyers of flats in the 40-story Twin Towers in Noida, the demolition of which was directed by the court in August 2021. The bench of Justices D.Y. Chandrachud and A.S. Bopanna was hearing contempt pleas by the home buyers alleging that while on the one hand, Supertech had invited them to collect their money, on the other, when they approached the company, they were told that the money would be paid back in installments, together with certain deductions which were not indicated by the court. The court came down heavily upon Supertech and warned that the directors would be sent to jail if they did not return the buyer's money at the earliest. The Supreme Court has stayed the directions issued by the Punjab and Haryana High Court to OLX India to adopt a screening mechanism with respect to the sellers who could post an advertisement on its platform. The bench of Justices U.U. Lalit, S. Ravindra Bhatt and Bela M. Trivedi was considering an SLP assailing a Punjab and Haryana High Court's order, wherein the High Court had passed directions against OLX while considering a case of a person impersonating another to upload a sale advertisement in the online platform. The top court ordered that pending further consideration, the effect and operation of the order under challenge would remain stayed. The Supreme Court has issued notice in an interlocutory application filed by an overseas citizen of India candidate seeking parity with Indian citizens with regard to the fees charged by the Indian Institute of Technology. When the matter was called for hearing before the bench of Justices S. Abdul Nazir and Krishna Murari, counsel for the petitioner submitted that IIT Madras was asking the petitioner to pay fees as charged from foreign nationals. She referred to the order passed by the court last year permitting OCI candidates to attend NEET counselling in general category at par with resident Indians. Solicitor General of India Tushar Mehta at this juncture entered appearance and sought time to file reply for the same. The Supreme Court has observed that the employees of the autonomous bodies cannot claim as a matter of right the same service benefits on par with the government employees. The state government and the autonomous board or body cannot be put on par, and the employees of the latter are governed by their own service rules and service conditions, the bench, comprising of Justices M.R. Shah and B.V. Nagaratna, observed in the judgment. The court also observed that interference by the judiciary in a policy decision having financial implications or having a cascading effect is not at all warranted and justified. Emphasizing the duty of the court to encourage genuine settlement of matrimonial disputes, the Supreme Court has set aside conviction of a man under Section 498A of the Indian Penal Code. In this case, the husband was convicted under Section 498A IPC and was sentenced to undergo simple imprisonment of 3 years. Sessions Judge dismissed his appeal. Partly allowing the revision petition, the High Court of Jharkhand, taking note of the settlement between the parties, confirmed the conviction under Section 498A IPC while reducing the sentence to the period of imprisonment already undergone. In appeal before the Apex Court, the issue raised was whether the High Court, even after taking note of the settlement of the parties resolving their matrimonial disputes, has erred in not setting aside the order of conviction altogether. The bench of Justices Dinesh Maheshwari and Vikramnath opined that maintaining of conviction of the appellant of the offence under Section 498A IPC would not be securing the ends of justice. The Supreme Court has observed that a High Court cannot enter into the merits of the claim in an appeal under Section 37 of the Arbitration and Conciliation Act 1996. In this case, the arbitrator directed a party to pay a sum of Rs 9.5 lakhs. The other party filed an objection petition before the ADJ Chandigarh under Section 34 of the Act against the award passed by the arbitrator, which was dismissed. Thereafter, a further appeal before the High Court under Section 37 of the Arbitration Act was filed. The High Court considered the merits of the claim and allowed the appeal. The Apex Court in appeal held that the High Court had exercised jurisdiction not vested in it under Section 37 of the Act and restored the award passed by the arbitrator. Let us now go over judgments from the High Courts and other courts. In a rather important development, the Delhi High Court is hearing petitions which have challenged the exception to Section 375 of the Indian Penal Code, which exempts marital rape from the offence of rape. A bench of Justices Rajiv Shankar and Sir Hari Shankar during the hearing discussed the possible legislative reasons for the exception to Section 375 IPC. The petitioners have made several arguments, including that marital rape exception fails to pass the constitutional test of Articles 14, 15, 19 and 21. Senior Advocate Colin Gonsalves, appearing for one of the petitioners, argued that marital rape is the biggest form of sexual violence against women which is never reported, analysed or studied. Senior Advocate Rajshekhar Rao, appearing as amicus curiae, also supported striking down of the exception and submitted that exception for marital rape is based on an outdated concept of marriage, presuming consent. The proceedings in this matter are continuing and we will keep you posted about the developments. The Calcutta High Court on January 13th directed the State Election Commission to consider postponing the conduct of the upcoming municipal elections in Siliguri, Chandarnagar, Bidhannagar and Asansol for a short period of 4 to 6 weeks in wake of the galloping speed with which the COVID cases are increasing in the state of West Bengal. A decision in this regard has to be taken by the State Election Commission within 48 hours, the court directed further. The Allahabad High Court has recently observed that in matters where the allegation is with regard to custodial death, judicial inquiry under Section 176, subsection 1 capital A CRPC cannot be allowed to drag for as long as these are instances that have to be viewed with greatest sensitivity and concern. The bench of Justice Ashwini Kumar Mishra and Justice Deepak Verma made this observation while hearing the plea of one Suresh Devi, whose son was allegedly murdered in police custody in December 2020. The Calcutta High Court has asked the West Bengal state government to file an affidavit disclosing the measures which can be taken to avoid child trafficking incidents in the future. The bench of Chief Justice Prakash Srivastav and Justice Kesang Doma Bhutia sought details on the subject while dealing with a PIL filed raising the issue of child trafficking in the state. The PIL, moved by a petitioner in person, Ramaprasad Sarkar, referred to the alleged child trafficking racket busted in Salkia, Howrah on 20th November 2021 and also raised the grievance that no proper action has been taken in the case till date. The Kerala High Court has held that writ jurisdiction cannot be invoked to challenge the appointment of an arbitrator, since such grievances should be redressed as per the provisions of the Arbitration and Conciliation Act 1996. The bench of Justice P.B. Suresh Kumar ruled that there should not be any judicial interference in the course of the arbitral proceedings for redressal of such grievances. The Competition Commission of India has directed a probe against Google with respect to allegations of abuse of dominant position raised by Digital News Publishers Association. The association had filed information under Section 19(1)A of the Competition Act 2002 against Alphabet Incorporated, Google LLC, Google India Private Limited and Google Ireland Limited. Noting that Google prima facie abused its dominant position in relation to news aggregation services, the CCI ordered the probe. With this, we come to the end of today's episode. If you're new here, do subscribe to LiveLaw and click the bell icon to not miss any of our videos. I am Taniya Pandey and you're watching Courts This Week. Have a great day.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.